And I want to touch on one other thing real quick while I got the microphone. You don't need to make arrests. All you need to do is remove them from office with whatever force is necessary. That's not as potentially violent as moving for arrests. We were talking earlier about doing the arrest thing, and we don't need to do that. All we need to do is have sufficient force to remove them from their offices and maybe even the sheriff there. So that's two different points. I yield.
Charles, that is an excellent suggestion about removing them from office rather than indicting them. And that did work here in the state of Georgia back in 1953. That actually happened where a grand jury ordered the governor to remove a sheriff, and that's exactly what the governor did. I'll yield.
That is a quo warranto.
Quo warranto plugs in. Yeah, like private attorney general. It's all related.
But you see, you have your citizens have the authority to convene themselves as a unincorporated association. So right there, that is protected under the freedom of assembly, peaceable assembly. And then they arrive at a decision, and then they either send it directly to the governor or they march on the courthouse and get the grand jury and say, look, we have made a decision. We want them people out of office, and you need to make it happen right now. Well, got to understand, everybody sitting on that grand jury is a neighbor to everybody on the other side. They're not about to offend their neighbors. They don't care about that politician. Yeah, the politician might be a neighbor, but he's one. I'm a juror, and I'm sitting here looking at 20 or 30 of my neighbors out there telling me that they're ticked off. I got to do something.
Yeah.
So then grand jury gets in on the thing, and then they also say, okay, governor, remove them. They send the governor a presentment and say, remove these people now. And the governor will have to remove them. Now, I don't know a governor in any state that's going to buck a grand jury.
Well, if I may, in regard to the... Yeah. Were you finished, Paul?
Yes, I'm sorry. I yield.
Oh, okay. In regard to the proposal of holding a citizens' grand jury or a public grand jury of the people, common law grand jury, trial by jury, or however, how would you describe your proposal, Charles, briefly?
Well, the grassroots, spontaneous, natural right to form committees of judicial inquiry. That's essentially what a grand jury is. I've talked about judicial inquiries before.
Well, what would the official procedure be? Would it be a grand jury impaneled by the common law rights of the people?
I'm sorry, Michael. I lost the essence of your question in my phone switching.
No problem. What would you call your particular strategy? The idea of impaneling a grand jury of people under common law authority. Would you call that a trial by jury, a grand jury inquiry?
May I?
I would call it. I'd call it a judicial inquiry. Inquiry. There's a number of different phrases. There's latitude there for packaging the wording in manners that are most strategic to the cause of justice.
Yeah, I like the inquiry label. That's non-offensive and very digestible. Now, what would you call the procedure, the process? What kind of a process would it be? Would we hold a court? Would we have a conference? How would you propose that meeting take place?
Well, if you've got somebody willing to assume a judicial power, yes, you could form a court right there. You could form a county court or a precinct level court interested in county business.
Absolutely.
And, yeah, I have no problem with that. Totally agree. And you would do this under common law authority, correct?
Correct, 100%.